Last Friday, the Supreme Court of Singapore released to public a very important judgment. It has set aside a SIAC arbitration award made against PVN for over $530 million and overturned the Singapore High Court's earlier remission order. The Court of Appeal held that the arbitral tribunal's conduct had amounted to such a serious breach of natural justice that there was a reasonable suspicion of bias, and with the result that the tribunal could not be entrusted to fairly conduct a review of its own previous decision. Therefore, the part of the award in favor of Power Machines, PM, of Russia had to be set aside on grounds of breach natural justice. This judgment has now also reopened PVN's substantial counterclaim for $2.69 billion which the tribunal had previously dismissed. PVN's lead counsel, Dr. Colin Ong KC of Eldon Law and 36 Stone Chambers appeared before the Singapore Court of Appeal, leading Daniel Koh and Genevieve Wong of Eldon Law LLP. In the arbitration, PVN instructed Dr. Ong and a team of lawyers from EPLegal working under Tony Nguyen. Singapore's Brattle brothers acted for PM before the Court of Appeal and in the arbitration alongside lawyers at Diakin Gortsunyan and Partners, a Russian firm. The dispute arose under an EPC contract to build the Long Phu thermal power plant in southern Vietnam. PM was the main contractor for the project, but suspended work in 2018 after it was hit with U.S. sanctions over its commercial activity in the Crimea. PVN halted payments to the Russian company, whilst negotiations took place to find a way around the imposition of the sanctions. Eventually, PM served 2 notices of termination in swift succession, the first citing the U.S. sanctions as a force majeure event, the second relying on non-payment of amounts due from PVN. In 2023, an SIAC tribunal chaired by Australian Professor Doug Jones issued an award of more than $500 million in favor of PM. In July 2024, Justice Chua Lee Ming suspended PVN's set-aside proceedings after finding that the tribunal had breached the fair hearing rule, but decided to remit the award to the tribunal to rectify the breach. The Court of Appeal disagreed with Justice Chua that remission was an appropriate remedy because the tribunal's breach of the fair hearing rule was serious in nature, and the tribunal's decision at para 548 was a pivotal decision that potentially went to the heart of the dispute on liability. If the tribunal had concluded that the invalid first notice did in fact bring about termination, this would likely have meant that PM would be found to have wrongfully terminated the EPC contract, which we imagine could have major ramifications on the incidence and quantum of damages payable. EPLegal is very pleased to be PVN's instructing solicitor for the whole dispute. We are thankful to our client's counsel team, our lead counsel, the partner firms and the whole work team for contributing to this landmark victory.